Monday, April 27, 2026, AGNDD Intelli Report topic. Supreme Court wrangles with police use of cell location data to find suspects. Please pardon any visual and informational inaccuracies in this partially AI-generated article-based video. Supreme Court reviews police use of cell location data to find criminals. Geofence searches allow law enforcement to find suspects and witnesses by sweeping up location data from cell phone users near crime scenes. A 2019 robbery at the Call Federal Credit Union in Midlothian, VI, led law enforcement to turn to a so-called geofence warrant in an effort to find leads. Credit: Steve Helber, Associated Press. By Annie Marimo, reporting from Washington, New York Times, April 27, 2026, 5:02 a.m. ET. When the Call Federal Credit Union outside Richmond, VA was robbed at gunpoint in 2019, the suspect took $195,000 from the bank's vault and fled before the police arrived. A detective interviewed witnesses and reviewed the bank's security footage, but with no leads, the officer relied on a so-called geofence warrant to sweep up location data from all the cell phones in the vicinity of the bank for the 30 minutes before and after the robbery. The data he gathered eventually led to the identification and conviction of Okello T. Chatri, now 31, a Jamaican immigrant who came to the United States in 2017. Geofence searches have become increasingly popular as a tool for law enforcement, but critics say they put at risk the personal data of everyday Americans and violate the Constitution. Mr. Chatri challenged the use of a geofence warrant in his conviction in a case that will be heard by the Supreme Court on Monday. The justices will examine how the Constitution's traditional protections apply to rapidly changing technology that has made it easier for the police to scoop up vast amounts of data to assemble a detailed look at a person's movements and activities. It has been 8 years since the court last took up a major Fourth Amendment case involving the expectations of privacy for the millions of people carrying cell phones in the digital age. In that 2018 case, the court ruled that the government generally needs a warrant to collect location data drawn from cell towers about the customers of cell phone companies. The court has also limited the government's ability to use GPS devices to track suspects' movements, and it has required that law enforcement get a warrant to search individual cell phones. In Mr. Chatri's case, the government did obtain a warrant, but one that his legal team said was overly broad, violating Fourth Amendment protections against unreasonable searches. Millions of Americans use a Google service known as Location History, which gathers data about every 2 minutes about where its users travel and when. Unlike traditional warrants, which target an identified suspect based on probable cause that they have committed a crime, geofence warrants operate in reverse. Law enforcement draws a virtual fence or boundary around a geographic area where a crime has been committed and asks Google for data on every user whose device happens to be in the area during a particular time. Mr. Chatri's lawyer, Adam G. Unikowski, compared geofence warrants to fishing expeditions, saying they allow the government to search first and develop suspicions later, in violation of the Constitution and the long-standing prohibition against warrants that are too broad or general. The technology may be novel, but the constitutional problem it presents is not, Mr. Unikowski wrote in a court filing. The potential for abuse is breathtaking. The government need only draw a geofence around a church, a political rally, or a gun shop, and it can compel a search of every user's records to learn who was there. A person's location history, which can be reviewed, edited, and deleted, is private data, Mr. Chatri's lawyer said. The lawyer argued that even if Mr. Chatri had agreed to share it with Google, he had not agreed to share it with the government. D. John Sauer, the Solicitor General, countered that Mr. Chatri had voluntarily shared his location data with Google. Similar to a person's bank or phone records, which are held by a business, Mr. Sauer argued there is no expectation of privacy for information that someone chooses to share with a third party. Plus, The administration contended that surveillance video showed Mr. Chatri holding his cell phone just before the robbery, meaning he had chosen to keep it with him during the crime. Mr. Sauer argued that a person in Mr. Chatri's position has no reasonable expectation of privacy over the stored location data, and that the time period specified by the warrant was too brief to be overly intrusive. Google says it stopped responding to geofence warrants last year because the company no longer stores such data and instead keeps location data on each user's device. But law enforcement has made geofence requests of other tech companies, including Apple, Lyft, Snapchat, Uber, Microsoft, and Yahoo, meaning the Fourth Amendment questions before the justices remain relevant. Officers used automated license plate readers, for instance, to help identify the man suspected in the Brown University shooting last year. Investigators identified the Golden State Killer using artificial intelligence-powered genealogy tools. In Mr. Chatri's case, a federal judge said the geofence warrant violated the Fourth Amendment because it did not meet probable cause requirements. But the judge allowed the evidence to be admitted in court, finding that the officer who requested the warrant had acted in good faith. Mr. Chatri eventually pleaded guilty to charges related to the robbery and is serving a nearly 12-year sentence. A divided three-judge panel of the U.S. Court of Appeals for the Fourth Circuit ruled against Mr. Chatri, but for a different reason. The panel found that the search was valid because Mr. Chatri did not have a reasonable expectation of privacy for the 2 hours' worth of location history data that he voluntarily shared with Google. Mr. Chatri asked the Supreme Court to weigh in after a full complement of Fourth Circuit judges divided 7-7 and, in a one-sentence order, left Mr. Chatri's conviction in place. In the last major Fourth Amendment case heard by the court, Carpenter v. United States, the justices in 2018 made a major statement about privacy in the digital age. In general, they said, law enforcement must seek a warrant for cell tower location information. The court found at that time that it did not matter that the records at issue were in the hands of a third party. But the court's membership has changed since that decision. Chief Justice John G. Roberts, Jr. wrote that opinion joined by 4 justices who had all been appointed by Democratic presidents, including Justices Sonia Sotomayor and Elena Kagan. Of the court's other current members, Justices Clarence Thomas, Samuel A. Alito, Jr., and Neil M. Gorsuch dissented. Google did not take a position on the legality of the warrant in Mr. Chatri's case, but told the court that it had advocated robust Fourth Amendment protections for sensitive data such as location history, and had objected to thousands of geofence warrants that it believed were overbroad and swept up the data of hundreds and sometimes thousands of people. Annie Marimo covers the Supreme Court for The Times from Washington. Comments. Bob, Colorado, 4 hours ago. I don't think anyone should have any expectation of privacy when it comes to any digital activity or activity that takes place in a public sphere. That's just the world we live in, which unfortunately seems to have left the Constitution in the dust a long time ago. Technology increases people's capabilities. Thus, keeping the same level of security requires less privacy, because the danger an individual can potentially pose is greater. However, the idea that tech companies, and thus advertisers or anyone else with money, should be allowed to access and use all information, but the government should not, is entirely backwards. We've seen how this data, especially when combined with AI, can be used to build profiles and subliminally control people. I don't mind sacrificing some privacy for security and convenience, but I do mind sacrificing freedom. In the big picture, Americans have a lot more at stake here than just privacy. I don't care if some random TSA agent in a different room sees my junk. I care very much if some random oligarch spends a couple $100 million on a political campaign and uses this data to manipulate everyone into voting for their preferred candidate. Once again, SCOTUS is years behind on these issues. Proactive legislation from Congress should not be too much to ask for, but it seems like they've been cowed by the executive branch and now spend more time on political theater than proactive leadership. CJ, Redwood City, 4 hours ago. This is a difficult and complicated issue. Too bad we have a Supreme Court that will probably consult with the White House to decide how to resolve it, instead of relying on the law and precedent. Sadly, we can no longer depend upon this court to protect individual rights or respect prior decisions. Margot, Atlanta, 4 hours ago. No argument that tools used to apprehend and convict a criminal should be considered valid. If the criminals have access to and use electronics to commit crimes, they should not be allowed an advantage over law enforcement. In other words, when electronic or personal surveillance is used to catch criminals, they don't get to complain and try to use it as a get-out-of-jail-free. Although definite limits need to be set, a dragnet can catch innocent people, and that needs to be resolved quickly, leaving the main question of should a warrant be used to deploy a dragnet? Mike, Florida, 3 hours ago. I think this isn't as clear-cut using the narrow premise of this case and could be resolved as such. A crime was committed. The location was a public location, no expectation of privacy, well-established law. It appears a warrant was obtained for existing data. It would be obvious the suspect was within the geofence as he was seen using his phone. It seems they know the physical description of the person from camera footage. None of this seems egregious as part of an actual criminal investigation where a crime was committed. Does this extend to who attends a rally, church, or meeting where no crime is committed? No way. But in this narrow scope, is it an issue? David Ezrati, Dayton, Ohio, 4 hours ago. Yet advertisers use this geolocation data for profit with impunity. Either we are going to have privacy and control of our data, or we're not. I made a shirt to sum up my feelings on this. Make Orwell fiction again. Schwa, the North, 1 hour ago. For all of you defending these practices, you do realize that our founding fathers would have been rounded up by the British in about 5 minutes after they started considering independence, right? The short-sightedness of people who have no grasp of human history is what makes things like a Trump presidency possible. Rich, Western New Jersey, 4 hours ago. Law enforcement's argument is that Americans who fail to understand the extent to which corporations collect their activity data should accept that law enforcement can use such data in cold searches. Law enforcement isn't Big Brother, you see, it's merely Big First Cousin. Alexander Hagan, Queens, New York, 4 hours ago. Benjamin Franklin. Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Anti-fascist, a banana republic, 3 hours ago. It seems innocuous enough until it's not. It's likely that the Supreme Court will rule in favor of it being innocuous but provide little or no guardrails for when it is not. Else Lerner, Woodside, California, 4 minutes ago. We are being forced to have cell phones. In order to do any business at all these days, you are required to have a cell phone. Now it looks like the government has the right to know where you are at any moment. I hate the damn things, yet I have one because it is not possible to exist without one. Plombard, Ferndale, Michigan, 40 minutes ago. Hang on here. The headline: Police use of cell location data to find criminals should read, Police combing through hundreds of innocent people's cell location data to find an alleged criminal. David, USA, 3 hours ago. All it takes is one rogue cop to ruin your life. Alex, Georgia, 2 hours ago. Mr. Sauer argued there is no expectation of privacy for information that someone chooses to share with a third party. This is an astonishing argument. It would negate the right to privacy in nearly everything. Tom, Virginia, 40 minutes ago. When I allow Google to see where I am, I only want them to correctly place a dot on a map to show me where I am, not show Kash Patel where I am. Al M., Norfolk, Virginia, 4 hours ago. We've become a country where all of us might as well be wearing the ankle bracelets some criminals have to wear for police monitoring. At very least, turn off the locator on your cell phone, Also realize you don't have to carry it with you. Any calls received will be listed on your phone so you won't miss anything.
Thank you for watching this AGNDD Intelli Report, dear viewers. Please like, subscribe, and click the bell button to get notified during new uploads. And make sure to tune in next time. Stay safe and healthy. Cheers!